I also would like to thank Jacqueline Dow Hall and all of the organizers for this terrific conference. And I'm also excited and a bit nervous to be presenting this work here. This is also part of a larger book project that I'm currently at work on. I'm going to take a slightly different tack through some of the same territory that Nancy covered. And I want to preface this by suggesting that one way to think about, I think, both of these papers, but especially mine, is the relationship between civil citizenship, or civil rights, and what, as Nancy argued, what Marshall and then Alice Kessler Harris, borrowing Marshall, called social citizenship, and what that relationship has been like in the late 20th century. So let me get started. In the late 60s, letters by the hundreds arrived each year at the San Francisco apartment of abortion activist Patricia McGinnis. Quote, "I have thought with myself about the moral aspects of this," one writer confessed. "I have tried all kinds of home remedies people have suggested," another admitted. All of the letters were written when abortion was illegal. Virtually all sought the safest and most discreet way to end a pregnancy. Quote, "Last week I tried to do it myself with some pointed objects and nothing happened. I'm desperate and will do anything." In the same years, hundreds of letters arrived at the offices of the Chicago Defender, that city's distinguished African-American newspaper. They sought the advice of Leonton Hunt, a Planned Parenthood official and author of the column, "Keep Your Family the Right Size." Quote, "I live in a project," a Mrs. A.N. explained, "and almost all of my good friends and neighbors are patients at Planned Parenthood. Do all the pills work the same way, or are they different?" she asked. A panicked Mrs. R.M. confessed that, quote, "I have 7 children. Now I am pregnant again and just worried sick. Please tell me where I can go to get an abortion." Did the women who wrote to McGinnis and Hunt in the mid-1960s require privacy? In what meaningful sense was privacy a resolution of the dilemmas that they faced? We might ask the same question of a young unmarried woman on welfare, of a lesbian seeking custody of a child, of a gay man discharged from the army. It's a reasonable question, because in the years between 1965 and the mid-1970s, privacy emerged as a new constitutional dimension of citizenship, of civil citizenship in the United States, most famously in the right to privacy articulated in the Roe v. Wade decision with regard to abortion, but in a number of other cases as well. Its emergence had 2 principal sources: a jurisprudential one, in which the courts, pushed by civil liberties and civil rights attorneys and by social movement activists, found privacy in the Liberty Clause of the 14th Amendment. And it had a sociocultural origin, in which the aforementioned social movements articulated a much less juridical and more common sense notion of the body, sex, sexuality, and intimate human relationships as private, what I'll call a kind of colloquial sense of what privacy means. My interest is how these 2 sources of ideas about privacy interacted, and crucially, how that interaction both clarified and confused the nature of privacy itself. The story of the emergence of privacy as a claim to reproductive and sexual self-determination was ultimately about modes of regulation of the family. Always more a social ideal and a legal construct than a literal reality, since the 19th century, the patriarchal family has been a paradox. Founded on the notion of a private, assiduously domestic sphere, it has simultaneously been subject to constant scrutiny and surveillance. Imagined as closed, it was always being opened, often by the law itself. Thus, birth control, abortion, obscenity, miscegenation, adoption, welfare, and sexuality laws, among many others, functioned since the late 19th century as a surveilling and regulating dimension of this putatively domestic or private sphere. Importantly, this surveillance was grounded in ideologies of race and class. Why then a talk on sex, reproduction, and privacy at a conference on the long civil rights movement? Well, there are many ways to answer this, but let me propose 3. First, privacy as a constitutional right was grounded by the Supreme Court in the 14th Amendment, the Reconstruction Amendment that had been used successfully by the NAACP Legal Defense Fund since the 1930s to chip away at state-sponsored racial segregation. The court applied the 14th Amendment to issues of sex and reproduction in ways quite different from its application to race. But the push for sexual privacy and the push for racial equality by the 1960s were on parallel tracks. Second, because the quest for bodily self-determination by women of all colors and gay men and lesbians of all colors overlapped with and drew inspiration from the politics of self-determination regnant then in black and Chicano movements more broadly. So there was considerable overlap. A focus on sex and reproductive rights enlarges the canvas of the civil rights and black power movements and forces us to see issues such as sterilization and abortion as embedded in the long African-American freedom struggle, however we conceive of that, and I'll reference the earlier panel. And third, because privacy as a legal argument, and this is where what I'm arguing touches on what Nancy's arguing, and third, because privacy as a legal argument was ultimately a very weak vehicle for advancing social justice for black Americans. And privacy as a political argument became one of the central ways that the new right opposed not just desegregation, but a range of social benefits, such as child care and access to health care for the poor. So privacy plays a number of very complicated roles in these arguments. So what then is meant by privacy? And here's where a slide would help. At work in my comments are three variations of privacy, each of which figures prominently in political debates over rights in this period. First, there is privacy as a reference to the private or domestic sphere, that ideological and physical space that I noted above that shaped the 19th century notion of the bourgeois family and its ideology of respectability. Second, there is privacy as a reference to the arena of life outside of state or public policy. This is really the kind of private that Nancy's talking about. And finally, there is privacy as something like what Kenneth Karst has called intimate association, something like intimate or sexual privacy, a space of individual liberty and conscience with regard to the sex and body. Only one of these definitions of privacy appears as such within the jurisprudence of the 1960s and the 1970s, and that's the intimate association version. But all three notions of privacy operate in crucial ways in the political lexicon of social movements and in the way that social movements are relating to the state and then ultimately to the rise of conservative movements as well. One final observation about privacy. In a seminal 2002 article in Differences, Susan Gall has argued that our language is really bereft of adequate metaphors for expressing how public and private actually function in social and political life. Hence our talk about boundaries and multiple publics and even the personal is the political. Gall poses a new metaphor that is imperfect, but it does allow us to escape some of the existing traps of that public-private language. The relationship between public and private, Gall writes, is that of a fractal. And here's where I have a nice picture of not a cantaloupe, but oh shoot, I can't think of it. Anyway, a vegetable that's like a fractal. So what is a fractal? That really helps, doesn't it? A fractal describes a formation in which each part is more or less a copy of the whole. Okay, so cauliflower, broccoli sort of approximate a fractal. That is to say, no matter how deep into the distinction between public and private we go, new publics and privates are always present. Inside every public, there is another public-private distinction. Inside every private, there is a public-private distinction, and so on in an endlessly regressing series. So that's just something to sort of keep a framework in mind. Let's start with reproductive rights. I want to begin there. The signal contribution of the feminist, gay, and lesbian and women-centered political resurgence of the late 1960s and 1970s was to call our attention to the fact that women's bodies are both individual and social at the same time, embedded in multiple public and private worlds. For social equality to have any meaning, it would have to recast a women's status and power in both kinds of arenas. Women's liberationists and women-centered activists of color, of course, did not enter the political consciousness of the nation calling for privacy. Privacy emerged slowly as part of the more important objective, equality. Indeed, at various times and places, women called for liberation, equality, equal access or opportunity, human rights, humanist values, the right to control their bodies, and so on. They called into question the boundary between public and private itself. Their politics, from the personal is the political to double jeopardy, were not demands for privacy, but anthems that declared oppression in the private sphere to be a political problem. They wanted to do what Nancy was talking about, take these heretofore private concerns and move them into the public arena in a meaningful way.